each and every one of you into the courtroom for the continuation of the debate that we started this morning. After a few minutes, we will listen to arguments from both sides. Team Bombay, Team 1, Bombay 7-day Adventist High School, who will be debating on the affirmative or the proponent of the proposition, and Yap High School, representing the state of Yap, will be debating on the negative side of the proposition. So debaters, are we ready to proceed? Okay. Judges. And now we will proceed on to the third debate this afternoon. And at this time, I would like to invite proponents of the proposition. You have 3 minutes for your introduction.
Good afternoon, honorable judges, moderator, worthy opponents, ladies and gentlemen. Warm greetings and my respects to everyone. Land is one of the most important possessions to the Fsm people because it is intimately tied to our cultures and our livelihoods. And because of the unique land laws of each of the 4 Fsm states, it is important to recognize this individuality and grant the state courts exclusive jurisdiction over cases involving land. That is why, today, my team and I stand strongly in favor of the proposition which states, and I quote, "Now, therefore, be it resolved that Article 11, Section 6b of the Fsm Constitution shall be amended to give the state courts exclusive jurisdiction over cases where the interest in land is at issue." End quote. Honorable judges, because this debate topic comes to us in light of the proposed amendments from the 4th Fsm Constitutional Convention, the affirmative team finds it appropriate to define the phrase interest in land at issue the same way that the delegates from the 4th Fsm Con defined it, which is to mean, and I quote, "where ownership of land, transfer of title to land, and registration of land is at issue." End quote. So essentially, all land cases. The affirmative team strongly believes that state courts should be granted exclusive jurisdiction over land cases for the following 5 reasons. Number 1, this proposition would amend the Fsm Constitution to more accurately reflect the original intent of the framers and the Fsm people who
begin. I would like us to take the time to acknowledge and pay our respects to everyone present here with us today, our honorable judges, the opposing team, our coaches, and the audience. My name is Tirin Ho, and my debate partner's name is Joey Jesse Xavier, and our alternative is Leilong. We are students of Yap Catholic High School here today to represent Yap State, and we are the opposing team arguing against the resolution that states, and I quote, "Now therefore be it resolved that Article 11, Section 6b of the Fsm Constitution shall be amended to give the state courts exclusive jurisdiction in cases where the interest in land is at issue." We are arguing against this resolution because of these 3 points. First, upholding fairness and justice. Second, diversity. And third, the language of the resolution. In the opposition's main argument, the 3 points will be expanded on through logical reasoning, evidence, and the professional opinion of the judiciary. Thank you.
We will now hear the main arguments from the proponents, and you have 15 minutes for your main argument.
Honorable judges, moderator, will you turn on the mic and raise your hand? Just press that. Honorable judges, moderator, worthy opponents, ladies and gentlemen. Warm greetings and my respects to everyone.
Today, my team and I stand strongly in favor of the proposition for 5 reasons. I will present the first 2 reasons in the affirmative main argument, and my partner will present the final 3 reasons. The first reason to support this proposition is that this proposed amendment will more accurately reflect the intention of the framers of the FSM Constitution and the will of the FSM people who ratified. When the delegates of the first FSM Constitutional Convention in 1975 met, one of the topics that received considerable attention was land issues. When you read the committee reports from 1975 CONCON, it becomes abundantly clear that it was the framers' intention to have all land issues resolved at the state courts. Standing Committee Report number 36, which was submitted on October 14, 1975, states, and I quote, "It is also clear to your committee that the laws and customs in each state differ. There is no one Micronesia land tenure law which can easily be applied by a court to any case involving a land ownership dispute. For this reason, it is your committee's belief that land issues must be resolved by the judicial system on the state level." End quote. Honorable judges, there is no mistaking this. When the FSM Constitution was drafted and ratified, the understanding was that all land issues were to be resolved at the state courts. This point is further supported by the fact that when the framers were delegating powers to the national and state government, they never explicitly gave the national government any powers involving land, and therefore, they implicitly granted the states these powers as per Article 8, Section 2 of the FSM Constitution, which states, and I quote, "A power not expressly delegated to the national government or prohibited to the state is a state power." End quote. However, today, the wishes of our founding fathers and the FSM people are being subverted because the FSM Supreme Court is currently hearing and deciding a subgroup of land cases. This subgroup of land cases are ones that meet one of the 2 criteria. Criteria 1, the land case involves a diversity of citizenship, meaning that the plaintiff and defendant are from different states, or one of the litigants is a foreigner or is a foreign party. Or criteria 2, the land case involves the FSM national government, and more to the point, the FSM Development Bank. Now, how does the FSM Supreme Court have jurisdiction over this subgroup of land cases? Well, the FSM Supreme Court cites Article 11, Section 6B of the FSM Constitution as the justification for its subject matter jurisdiction over this subgroup of land cases. This section states, and I quote, "The national courts, including the trial division of the Supreme Court, have concurrent original jurisdiction in cases arising under national law, and in disputes between a state and a citizen of another state, between citizens of different states, and between a state or a citizen thereof, and a foreign state, citizen, or subject." End quote. Now, the affirmative side thus concede that the current provision in Section 6B do seem to grant the FSM Supreme Court subject matter jurisdiction over land cases when it involves the FSM DB, or diversity of citizenship. However, that is why the affirmative team believes that the amendment in this proposition is necessary. Without this amendment, we will continue to apply the FSM Constitution in a way that does not align with the original intent of the framers. Moreover, the affirmative team would like to point out that the FSM Development Bank was established by national law in 1979. This was 4 years after the drafting process for the FSM Constitution in 1975, and 1 year after the Constitution was ratified by the FSM citizens in 1978. Because the FSM Development Bank established after the Constitution was ratified, it is reasonable to argue that the framers did not intend to grant an intuition like the FSM Development Bank to the right to file cases involving land mortgages at the national courts. Therefore, the affirmative team reassures its argument that the language in Article 11, Section 6B of the FSM Constitution must be updated to reflect the original intent of the framers and the people who helped ratify it. Clearly, more clarification is needed to establish that state courts should be the only courts to settle land disputes, regardless of diversity of citizenship or if the FSMVP is a party. By supporting this proposition, not only would we have a constitution that accurately reflects the will of the framers and the FSM people, we will have a constitution that does not blur the division between state and national powers. Which brings me to the affirmative team's second point. The second reason to support this proposition is that it will provide a clearer separation between state and national powers. When the national government infringes upon state powers and national powers, it can lead to major tensions between the two governments, which can also lead to confusion and unwanted consequences. Recall, the very real tension between the national government and one-based state government that arose because of the unclear distinction between national and state police powers when it came to quarantining. This ultimately resulted in the former FSM President David W. Panuelo arresting 5 one-based state government officials, including the then acting Governor Cristina Alnay. In response to former President Panuelo's decree to arrest, Governor Alnay wrote, and I quote, "We do not want to interfere to your powers and responsibilities. We respectfully seek reciprocation. As one band, let us work together amicably in serving our people." End quote. It was highly believed by the state government of Hubei that it was their duty to regulate quarantine and entry protocols within the state of Hubei. However, the national government also claimed it was their duty to regulate it. This is a blatant display of the confusion and tension that can arise when the separations of power between the state and national courts are unclear. The Constitution aims to communicate a very clear separation of state and national powers. But with the current language of the FSM Constitution, it appears to be quite vague and may cause constitutional confusion around exactly where state power stands. Now, my partner, Marchandra Russell, will explain our next 3 remaining arguments.
The third reason to support this proposition is that it would allow state courts to build on state precedents. The concept of precedents is incorporated into the doctrine of stare decisis, which is a Latin term that means let the decision stand. This means that courts would apply the law in the same manner to cases with the same facts in order to be consistent with their judgments. Some judges have stated that precedents ensures that individuals in similar situations are treated alike rather than a judge's personal views. Now, how is this related to our proposition? Well, since the National Court is applying the state land laws, they follow state precedents on land cases when they're deciding land cases involving diversity. This prevents the state courts from deciding on those cases and building off of them in order to strengthen their reasoning because they never had the opportunity to even hear or decide them in the first place. This then makes them unable to handle cases that were originally under their jurisdiction. Because of this, there was a time when state courts sent a land case with diversity to the National Court for a verdict due to their lack of experiences with such cases. According to the FSM Supreme Court reports, the Edsai versus Adam case was a land case that was originally brought to the state courts. It discussed disputes of land between diverse parties. One was a Belgian citizen, another was a French citizen, while the other was a German citizen. In short, there were diverse parties. However, this case was then sent back to the National Court due to diverse parties and the state court's lack of experience with these types of cases. The state courts were already perceived to be incompetent before being given the chance to establish precedents. This simply means that amending the Constitution will ensure that not only time and resources would be wasted because of mistakes like this, but also land cases with diversity would be properly settled in the courts where they belong. The fourth reason to support this proposition is that it would free up slots on the FSM Supreme Court's docket to hear cases that can only be heard at the national level. It has already been established in our first main point that all cases involving land should be adjudicated in the state judicial systems because the FSM Constitution and its framers recognize land to be purely a state matter. In the same way, there are many matters that are clearly of national character that can only be adjudicated within the national judicial system. By amending the Fsm Constitution to grant state courts exclusive jurisdiction over all cases involving an interest in land, the Fsm Supreme Court would be freed up to hear other cases that only cases involving land have taken up a considerable amount of slots on the National Supreme Court docket, which ultimately means that other cases of national character have either been deferred or will never be heard. According to the Fsm Legal Information System, in the Fsm Supreme Court's most recent interim, about 21% of those disposed cases were land cases. And in the interim before that, about 11% of those cases were land cases. These are valuable slots that could and should be filled with other court cases of national character. The fifth and final reason to support this proposition is that it would help eradicate the stigma that state courts are biased. As mentioned earlier in the first point of our main argument, the current provisions of Article 11, Section 6b of the Fsm Constitution grants the National Supreme Court diversity jurisdiction over land cases, meaning that when both the plaintiff and the defendant are diverse parties, are from different states, or if one of them is foreign, the Fsm Supreme Court has license to remove that case from the state and adjudicate it themselves. This is done in the name of ensuring the fair administration of justice and assuring the out-of-state or foreign litigant that their case will be heard in an unbiased court. However, this practice is problematic because it paints the state courts in a negative and, quite frankly, an offensive light. Effectively, what the current provisions of the Fsm Constitution are perpetuating is the stigmatization of state courts as biased and unfair institutions that cannot administer justice fairly when an out-of-state or foreign litigant is involved. In an article published in the Duke Law Journal titled "Beyond Bias in Diversity Jurisdiction," law professor Deborah Bassett asserts that this practice of licensing the removal of cases from state and local courts for the sake of diversity is counterproductive because, and I quote, "it reaches beyond the potential prejudice of one particular judge and instead paints an entire court system with the broad brush of bias," end quote. Let it be clear that this is the role and the sacred responsibility of a judge to adjudicate cases fairly and without the influence of personal biases. Furthermore, state court justices are trained professionals who are also experts at interpreting and applying the state's substantive law. Let us not stigmatize our state courts as incompetent at administering justice fairly. Instead, let us entrust all land cases to our state courts as was intended by the framers of the Constitution and the Fsm people who ratified it. Thank you.
Opponents, you now have 5 minutes to rebut the opponent's main argument.
So I will be using the links that the opposing team mentioned, that I have quite a few questions. So you guys mentioned that that this resolution and have been having more problems arise because of it. Now if we pass this resolution, then that can mean that there's going to be more problems that can still arise from it. And another one is that you guys were admitting that these state courts are biased, where we need to have like courts remain like remain fair and just.
Proponents, now you have 3 minutes to respond to the opponent's rebuttal.
Honorable judges, ladies and gentlemen, I would like to thank my opponent for their argument. However, my opponent stated that we were admitting that their state courts are biased. However, they completely misunderstood us. What we were saying was that we are saying that people think this amendment wouldn't help them prove otherwise, but this is what people think. People think, and this amendment will prove them otherwise. That is not what we're trying to say. Thank you.
Thank you. Now we will move down and hear the opponent's main argument. And you have 15 minutes for your main argument.
As stated in the introduction, we are against the resolution that the state courts must have exclusive jurisdiction over cases of land disputes in each state because of the 3 points. 1, to uphold fairness and justice. 2, diversity. And 3, the language of the resolution. Firstly, to uphold fairness and justice. In order to uphold fairness and justice, which is the mandate of any competent judicial branch, all parties and courts must avoid acts of bias. The language of the resolution itself is for the concept of bias. By opposing the resolution, it does not restrict any court from handling any land interest issues. This statement will be further explained in the later arguments. As still being stated, fairness and justice are still to be enforced throughout all the cases. Having the Supreme Court also deal with land disputes helps minimize biases from locals toward cases of such. State courts may face local biases or political influences, which operates at a national level and is insulated from local pressures. There is a greater likelihood of achieving fair and unbiased outcomes. Land disputes often intersect with federal laws and regulations. The Supreme Court's jurisdiction over federal matters allows it to interpret and allow federal statutes and regulations in land dispute cases, ensuring alignment with national legal standards. Land disputes can have far-reaching implications beyond individual states. The Supreme Court's involvement ensures that national interests and considerations are taken into account, facilitating the resolution of disputes in a manner that accounts for the broader impact on the country as a whole. Land disputes involving conflicting state laws can lead to uncertainty and inconsistency in outcomes. By centralizing these cases in the Supreme Court, conflicts between state laws can be resolved definitively, promoting legal harmony and reducing confusion for parties involved in land disputes. We all know that we are a small state, and as a small state, everybody knows everyone. And with this, the local judges have a more possibility of being biased. Our second point is diversity. In order to uphold fairness, differences must come into consideration. The Supreme Court can act as a protection to everyone, whether it is a citizen or a non-citizen. Article 13, Section 4 of the FSM Constitution states, and I quote, "A non-citizen or a corporation not wholly owned by citizens may not acquire title to land or waters in Micronesia." End quote. This is constitutional law. Therefore, it cannot at any point be violated. There should not be any case where a non-citizen is claiming land as their own, although it can be a problem for them when their partner, who is a citizen and a landowner, does not meet their ends of their agreement. In other words, there is precedent. If this case was taken to court, there would be considerably more assessing and consideration that has to come in place to avoid any mishaps and misunderstanding. It would not look good reputation-wise for the state courts to be the ones to handle this case. The Supreme Court can help to carefully assess and investigate this matter to accommodate all parties. According to the court decisions on customs and traditions, the constitutional government seeks not to override custom, but to work in cooperation with the tradition system in an atmosphere of mutual respect. This is taken from the case of Iriarte II, First Federated States of Micronesia, volume 255, page 271, on page 1982. It is by constitutional law that the judiciary must respect and take into consideration the traditions and customs of all the states. There is diversity in the Supreme Court that should be taken into consideration as well, which are our judges. Currently, as of right now, we only have one FSM citizen judge seated at the Supreme Court, which is the acting Chief Justice, Julie Carl Gorsu. The other judges are non-citizens of the FSM. However, they are still qualified to be judges of the Supreme Court because there is no law that prohibits them, any foreigner, from working for the FSM Supreme Court. According to the Yap State Court, there is a general agreement in which all judges must have some knowledge of the traditions and customs of all the four states. Our last point is the language of the resolution. The language of the resolution is not clear with the outcomes that comes with it. According to the official opinion of the Yap State Court, the language of the resolution is unclear. The Yap State Court gave assumptions as to what would happen if the resolution is passed, but none of it matters because the resolution does not make it clear on how. The language of the resolution is restricting fairness and justice in itself. The resolution once again states that the FSM Constitution shall be amended to give exclusive jurisdiction to the state courts in cases where an interest in land is at issue. That goes as far as to say that there will be in no circumstances can any interest in land issues be in cases under the Supreme Court. The cases will always and only be under the state courts. If the whole point of the resolution was to provide clarity to the original language of the Constitution, then the resolution failed because it creates other issues and questions. Once again, the opposition is against the resolution to amend Article 11, Section 6b, because fairness and justice must be instilled in the courts in order to avoid acts of bias. Second, taking into consideration the diversity within the courts. And finally, the language of the resolution does not leave room for the FSM Supreme Court to participate in land cases, and it is not specific. Thank you.
Proponents, now you have 5 minutes to do report. Opponents main argument.
Honorable judges, ladies and gentlemen, we appreciate the points raised by our opponents. However, we respectfully disagree and would like to address their points. If I recall correctly, my opponent stated that the FSM Supreme Court should be the one to hear land cases the National Supreme Court is more. In other words, helps in the fair administration of justice instead of the state courts, or more than the state courts. But I would like to argue that this argument is problematic because it paints the state courts as biased and unfair institutions that are incompetent at administering justice fairly. The judges at both the state and national court level are appointed and trained to apply the law and administer justice fairly. So no matter what court the judges are from, they are both still trained professionals and they are required to apply the law, what the law says, not based on what they think or who they know. It's always based on what the law says. And they also mentioned that fairness is something that any competent judicial system should have. So are they implying that the state courts are competent? Yes, thank you.
Opponents, you now have 3 minutes to respond to the opponent's rebuttal.
So, like we said, taking into consideration that we are a small country and that almost everyone here in each state knows everyone, it is more possible and more likely for the state court judges to be more biased to, against the people that they don't know because a family member or a family friend is part of the case. So it is more likely for them to be biased. Unlike the Supreme Court, which has more diversity and has foreigners as well, it is less likely for them to be biased because it is hard for them to really know the person directly.
Thank you. Now we will hear both sides' summation or conclusion, and we will begin with the proponent's summation. You have 4 minutes.
honorable judges, moderator, timekeeper, ladies and gentlemen. I thank the negative side for an enjoyable debate and for being great opponents on such an important topic for us today. The affirmative side reaffirms its position that it is strongly in favor of the proposition we are debating today. We believe that amending the Constitution to give the state courts exclusive jurisdiction in cases where an interest in land is at issue is in the best interest of our nation. We have provided you with 5 robust reasons as to why we support this proposition. Number 1. Article 11, Section 6B of the Fsm Constitution does not reflect the original intent of the creators. Furthermore, the Fsm Supreme Court's current application of this section is not in line with the understanding of the Fsm citizens who ratified the Constitution back in 1979. This point is further proven by the fact that powers involving land are implicitly granted to the state courts. This proposition will help to prevent the development of hostile tensions between the state and national governments because it will provide a clearer separation of power between the two governments. Number 3, diversity jurisdiction is preventing state courts from establishing and building on state presidents. If the state courts were finally given the chance to establish precedents in land cases with diversity, then they would build and establish precedents which would allow them to strengthen their verdicts over issues that rightfully fall under their jurisdiction. Number 4, land cases involving diversity jurisdiction and FSMPB cases are taking up slots of the Fsm Supreme Court docket that should be given to more urgent national issues. This proposition would allow the National Supreme Court to accept other important cases of national character on its docket. And number 5, Article 11, Section 6B of the Fsm Constitution currently grants the National Supreme Court license to remove state courts' land cases where diversity of citizenship exists. This practice undermines the state courts and stigmatizes them as incapable of administering justice fairly when cases involve out-of-state or foreign litigants. This is counterproductive and offensive. Supporting this proposition would help eradicate this stigma. Honorable judges, ladies and gentlemen, let us establish a national constitution that reflects the will of the people. Let us strengthen the unity of this nation by restoring to our states the exclusive authority to adjudicate all land cases. And let us empower our state courts and free up the national court to fulfill its other obligations. Therefore, let us support this proposition. Thank you.
Opponents, you have 4 minutes for your summation.
Taking everything into account, we would like to firstly thank the affirmative team for their points and evidence. Although we are against the resolution, we understand the affirmative side of the resolution. To restate, there are 3 main points that states as to why we are against this resolution, which are upholding fairness and justice, diversity, and that the language of the resolution is unclear of its intents. By embracing this amendment, it demonstrates the contradiction to justice and excludes the Fsm Supreme Court from any magistrate cases.
We will now move down to the last part of the debate, which is the questioning and remarks of the judges.
Thank you. The proponents argued today in reference to a standing committee report from the Congressional Constitutional Framework CONCON that was held. They stated that based upon that CONCON report and the fact that the National Fsm Development Bank was founded or established 4 years later, that it was clear that the intent was not to have the Fsm Development Bank to essentially have this power. However, the fact remains that the CONCON members largely began and formed the first Congress that was actually installed. So doesn't it suggest that the people who put and established the development bank in place were well aware of the fact that the legislation, the law, and the development bank would have this power to go to court under the Constitution? The same people who were involved in forming the Constitution were actually some of the same members of the first Congress.
Can you please repeat the question?
Yes. Your position is that because the framers of the Constitution had an intent for the state courts to have exclusive jurisdiction, and since the development bank was established 4 years by law in 1979, the framers did not have this intent for the development bank to be able to go to the national courts. But doesn't that actually support the contrary proposition, because it's the same individuals who were involved in the original CONCON when they established the Constitution? The same members were members of the Congress that established this bank in the national law. So they were well aware of what they were doing. So doesn't that support the opponents, that they were full aware of the intent of what they meant when they established this bank?
Yes, it does.
I have one question. So it seems like the conflict of interest issue is raised by the proponents to say that these type of cases where an interest in land is best addressed at the state court. That's your position, right, proponents? The opponents are saying that it's best to be addressed by the national court because I guess there won't be any conflict. It's more remote. The likelihood of a conflict of interest is less. Correct, opponents? So my question is, I guess you can both weigh in, but it might be directed towards the proponents. So what do you raise as a solution? If a conflict of interest issue, for example, everybody on let's use an example, the state court panel is all disqualified. What would be a solution that you would offer? What would happen with the case?
In other words, are you asking basically how you think the state courts would deal with cases involving diversity if this amendment would be passed?
So, not really. I guess my question is more, let's say you're the proponents of the resolution. Let's say the resolution passes, and these types of cases where there's an interest in land is now exclusively handled at the state court level. if all of the judges on the state court level happens to be disqualified because one of the arguments is that you're closer to the people, and so therefore, when it's a land issue and everybody on the panel cannot handle it, where would the case go? How would you propose it be handled? Please go to the podium.
If you're ready to answer, take the podium.
So, again, the opponents were stating that the chances are high that the judges might base their judgments off of personal biases. However, based on our research, based on what we know that judges are all, no matter what court they're from, we know that all of them serve to apply the law, just what the law says, and without the influence of personal biases. But if this were to happen, actually our team agrees that the chances are low of this happening, because again, all judges are trained and they know how to effectively and fairly apply the law in any case. But if this were to happen, then yes, it would most likely go back to the national court. But we agree, the affirmative side agrees that the chances are very low because all judges are trained to apply the laws fairly, and they even have trainings. And yes, that would be my answer. I hope that answers your question.
This question is for the opponents. You stated that the language of the constitutional amendment is unclear. What is specifically unclear? You stated that it raises other issues and creates other questions as provided by the GAP state resolution. Please expand on that.
Sorry, can you repeat the question again?
What is unclear in the constitutional amendment? Your argument is that number 3 argument of the language of the resolution provided by the COMCON is unclear, and that this was expressed or discussed by GAP State in their resolution. So what is exactly unclear about the proposed amendment? You said the intent is unclear. It creates other issues and questions, but did not explain what those other issues or questions were.
clarification. Your question is, you're asking what are the issues that comes with the resolution, because I stated that it's not clear.
Yeah, so what is unclear about it?
So from what, so we believe that what is unclear about it is like where I guess it can be like it's unclear because the resolution is saying that the state courts would get exclusive jurisdiction. So I was where my point came from was it came from, I guess, me wondering where the cases would go if it can't go to the state court, and it says exclusive jurisdiction. Therefore, if we pass on the resolution, the cases can no longer go to the national. And some of the assumptions that the court mentioned to me was that there was going to be a trial division and a appellate division. Although we are not so sure about this because the resolution does not specifically state that. So I guess, yeah, that is what I meant by it not being clear.
Thank you. I believe that's the last question. Oh, I'm sorry. There's another.
Okay, I have a question for the opponents. And it seems like one of the big issues is the conflict of interest, so I'm going to switch over the question that I have for the opponents to the opponents. You mentioned that I guess it's a good thing to have the national court handle these types of cases. And you did note in your arguments that the national court is comprised of both a citizen and two non-citizen judges. I may have missed any argument you have raised on that, but I was wondering if you could clarify these for me, whether you believe that that is a good thing or not.
So, yes, we do believe that it is good that the Supreme Court has diversity. Because for us, we believe that as an FSM citizen, you have a bit of a knowledge of the traditions and customs. And that you can, I guess, help the other judges, the other court judges, help you to, where you guys compose each other's ideas on cases. And it can be more fair.
Thank you. So, this is my last judging of the competition. Thank you, everybody. I've been impressed so far. I'm sure everybody will enjoy it tomorrow. Thank you.
Final question from the panel, and that's conclude the debate between Bombay Team SCA and Yap High School. Ladies and gentlemen, let's give both team a big round of applause. You may be excused. In our program today, we have only 3 debates, and the one just completed, that's the 3rd debate in our program, and we will continue tomorrow for the last 2 debates. And the schedule for tomorrow, ladies and gentlemen, we will start at 9 in the morning. So at 9, so we can start at time. We only have 2 debates tomorrow. That's the announcement, and that's conclude today's program. Thank you, and I will see you.